Okay, we'll now hear the arguments in State versus Graham, but let me first welcome the students, the government students from Marshalltown High School. I'm glad you're with us this morning, and we hope you find this interesting as you observe. So thanks for being here. Ms. Wilson, you may proceed.
May it please the court. I'm here today representing defendant appellant Bradley Graham. In 2010, he pleaded guilty to one count of sexual abuse in the third degree based on having a sex act with a 13-year-old girl. The defendant was 17 at the time. Because it was a forcible felony, the court ordered him to serve 10 years in prison, and he was also required to be on the lifetime special sentence, and as a result of that, have a lifetime requirement of the sex offender registry. He discharged his prison sentence after 4.5 years in April of 2015, and he was released. He is now on both the special sentence and the sex offender registry. I want to begin with the cruel and unusual punishment argument. A lot of the things I will be arguing today are relevant to all of the issues I have raised. And I'm not going to go through all of the U.S. Supreme Court and the case law of this court on juvenile sentencing issues. This court is very familiar with it all. But ultimately, it culminated in State v. Lyle here that invalidated all mandatory minimum sentences for juveniles, finding that a one-size-fits-all approach is not appropriate for juvenile offenders. The mandatory special sentence of parole is cruel and unusual as applied to both the special sentence and the sex offender registry. Of course, the first thing you have to look at is whether it is punishment. Under Lathrop, we know the special sentence is, in fact, punishment. It is. That's not as clear with the registry provisions. However, given the 2009 amendments to the sex offender registry, which were in line with the Adam Walsh Act requirements that created, or the SORNA as it's called, Sex Offender Registration and Notification, many states, including now the Sixth Circuit, have found that the new registry provisions are indeed punitive. And they are punitive even as to adult offenders. Of course, in this case, we're limiting it to juvenile offenders. But
I mean, wouldn't we have to overrule those cases like Formaro and Searing in order to find that they're punitive?
Absolutely not, Your Honor, because the provisions are different. I looked at...
It strikes me that the reasoning of those cases is pretty broad, and the differences in the restrictions aren't going to alter would still fall within the reasoning of those cases.
Well, the reasoning of the cases, and I'm not suggesting the intent of the legislature is any different. You know, Searing and Pickens, they talked about how there is a non-punitive purpose. There is a remedial purpose, which is the protection of the community. And I'm not disagreeing that the legislature may still have that in mind. But the restrictions that are currently in effect now are indeed more punitive. And two things you have to consider when you're looking at the Mendoza-Martinez factors are the rational connection of those restrictions to the non-punitive purpose and whether or not they are excessive. And in particular, when you're talking about juveniles, there is no more rational basis and it is excessive. And that is because of what we know about juvenile sex offenders and the statistics that are coming out. I cited the 2014 Sex Offender Research Council report. It has a lot of relevant statistics for this court's consideration. And that is, even in Iowa, the offense rate, the re-offense rate for juvenile sex offenders is significantly less than for adult sex offenders. It is essentially equal to juvenile non-sex offenders. And the SORC report says that's between about 3% and 5%, whereas adult offenders are much higher than that, at least double.
If there was another report and it reached a different conclusion, what would we do then?
Obviously, you have to weigh all the reports together to base an informed decision. but the reports are showing. You see it in the Pennsylvania case of In re JB. They looked at their own statistics, including national statistics, and they found that indeed there is a lower risk of reoffense for juvenile offenders. The reviews and reports I provided in the brief consistently say juvenile offenders have a lower risk of recidivism. And that is one of the things that are leading these other states and the Sixth Circuit to say that it is no longer consistent with the non-punitive purpose to have these sorts of very restrictive provisions against juvenile offenders. In fact, these restrictions may actually increase recidivism. That's because you're undermining the juvenile's support group. It's going to impact their ability to go to school, to find work. They have no work history.
That sounds like a policy argument that should be directed to the legislature. In fact, those debates have been going on in the Iowa legislature, right?
I would certainly say it would be well advised for the legislature to look at this information and alter the sex offender registry requirements accordingly. And certainly, they do provide some exceptions for juveniles in juvenile court. In juvenile court, the district court has the ability to provide a waiver if they find no risk of reoffense. In juvenile court, the court can modify the provisions if they do think the child or the juvenile should be on the registry. There are no such provisions here. And the problem is, again, we might actually be causing more of a problem than we're trying to solve.
Can you get off lifetime, the lifetime sentence, and can you escape the registry and so forth?
I'm very glad you asked that, because that is a question I brought up in the Court of Appeals argument, because I honestly was not clear. If you look at 906.15, there is a provision that specifically talks about the special sentence. And I'm going to see if I can't just find it right now. Basically, it says if you're convicted of a 709.3 or .4 offense, that a person serving a sentence under or shall not be discharged from parole until the person's term of parole equals the period of imprisonment specified in the person's sentence, less all time served in confinement. Now, when I originally read that, I thought, well, it's a special sentence. You don't serve any time in confinement. So does that mean you're never eligible for early discharge? And how do you early discharge life anyway? But what the Court of Appeals did, they basically referred back to the original sentence. So for my client, he has a 10-year prison sentence, which he's now discharged. He's discharged after 4.5 years. That meant that there was 5.5 years remaining. So what the Court of Appeals said was, then that means he can have early discharge of his special sentence after 5.5 years. Now that seems rational, but there's a little bit of an oddity there in that if the defendant had been given probation and was never in confinement, they would actually serve a longer term on the special sentence before early discharge than somebody who had been confined. The other problem is the Iowa Code section I provided, or the Iowa Administrative Code section I provided the notice of additional authorities on. If it's a 709.4 offense with the child, that provision says there's no discharge until maximum sentence has been served. Does that mean you don't get a discharge from the special sentence? It's terribly unclear.
I read the statute, that last piece of language, at least initially, the way you do, and I don't think a regulation can override the statute, can it?
I would think not, but again, my initial impression was you don't get early discharge. So it'd be consistent.
And if you can be discharged after 10 years, what's the problem with it? I mean, how does that then come under Lyle or any of those other cases? Because you get on parole, as your client is now on parole, and then after a period of time, he has the ability to discharge the special lifetime sentence and get off parole. Now, a juvenile that commits a Class A felony will never get off parole, right?
Potentially.
And we've upheld that.
Potentially. But again, I think it goes back to how we are looking at the special sentence of parole. Are we considering it as a mandatory punitive sentence to which Lyle does apply.
Okay, so I'm going to recast your argument, invite you to correct me, but in your client's case, there is a mandatory 5.5-year special sentence on parole. At the end of that 5.5 years, he will not have the special sentence, if I understand the statute correctly.
If he is discharged early, parole board doesn't have to release him early from the parole.
All right, so let me rephrase it again then. There's a 5.5-year mandatory minimum special sentence, and then after that 5.5 years, it's in the discretion of the parole board to be released from the special sentence. Is that correct? Okay, now, then what does the evidence show with respect to the parole board? I mean, do they release sex offenders? Do they not release sex offenders? Is there anything in the record, and does it matter?
What I provided to the court was the legislative fiscal note, which indicated that, no, the parole board generally does not release sex offenders early. The other thing I would point to, the state says, oh, but the parole provisions say that the parole board shall discharge once they believe that the person is capable of being a fully law-abiding citizen. And that's a mandatory provision. Well, it's not really, because if it's in the determination of the parole board, if it's in the opinion of the parole board, that is completely discretionary with the parole board.
Could be, but if what you're saying, I mean, if it turned out that you had what I call the 5.5-year mandatory special sentence, and then afterwards the parole board in its discretion would consider whether or not your client, poses a risk and so forth and so on. There might be some issues with respect to the scope of what I'll call the second look, but it makes it something less than a lifetime sentence. It's not a mandatory lifetime sentence at that stage, at least.
Not at that stage, although I will caution the court, as far as I know, there is no provision, as you have with release from confinement onto parole, where the parole board has to do an annual review. To my knowledge, there is no obligation for the parole board to review the case of anybody on a special sentence at any
That
set
may
time.
be, but that might not be right now, maybe. I'm not sure. I mean, in your client's case, conceivably, one could say, well, the first thing is this 5.5-year mandatory special sentence lawful? It might be. Let's just assume it is. And then he has an opportunity for review by the parole board. You might have a claim that you don't have an adequate opportunity for review at that point, and then that's a different issue. But sitting here today, we don't know for sure what the parole board is going to do, I don't suppose.
We don't know now, and obviously, I'm certainly not making an argument that at that point, if he's not getting a hearing, or if it's an improperly done hearing, that he wouldn't have administrative remedies.
So to press you a little further, obviously, we've read the Kansas case, and we've looked at the Ohio case, and the Sixth Circuit case. And indeed, it strikes me there is some evolution in the law of these cases. But they tend to turn, I think, and the state has suggested this in the brief, they tend to turn on the view that these are basically mandatory lifetime sentences. And it's not 100% clear that that's what we're dealing with the Iowa special sentence.
Iowa's a little bit different, I will say that, because a lot of these sex offender registry statutes in other states, quite a lot of them don't allow any means of modification or waiver. A number of them only allow modification or termination after 25 years. Iowa obviously is much better in that we have a 5-year waiting period, essentially. However, I want to say that when these cases are doing their analysis, as far as I know, New Hampshire was the only case in which the court said this factor, the inability to modify or terminate, is the determining factor in whether or not the registry provisions are punitive. Otherwise, it is simply one factor in the multi-factor Mendoza-Martinez.
But it may affect, I'm sorry to interrupt you, but it may affect the proportionality analysis. I mean, it may well be, let's just say, and even stipulate that it's punitive, but that's not the end of the day. The end of the day is whether it's proportional or not. And if you have, let me put it to you this way, if you had a so-called lifetime parole obligation, but you had individualized, kind of a regular individualized hearing on determining whether you should still continue on parole or not. I mean, that's a different, the proportionality analysis ends up being a little different, I think. Don't you agree?
Well, the proportionality analysis is a little bit different, but as far as whether or not it's punitive, again, that goes back to the multi-factor analysis.
But just because it's punitive doesn't mean you win,
Right,
I take it.
right. It's obviously the first step because as Justice Mansfield noted, we have not previously held these registry provisions to be punitive, though they are now.
So, again, at the risk of recharacterizing your argument, and you're suggesting that, well, okay, it's punitive, and B, although there's a possibility after 5.5 years, perhaps, that you might get out from under the special sentence, that glimmer of hope, if you will, isn't sufficient enough to affect the kind of a gross proportionality analysis? I mean, am I close to what your argument is, or?
Right, I mean, there might be some hope, but given the nature of juveniles and where they are in life, these restrictions are particularly harmful to them, especially when it comes to the registry provisions. And I see I'm out of time, and just briefly, I do want to mention that article from the New York Times where juveniles who go to school and their schoolmates find out that they're on the registry. You have juveniles who are literally walking into oncoming traffic to kill themselves. This is something that should be addressed. Thank you.
Thank you as well, Ms. Wilson. Mr. Hall.
Thank you. May it please the court, counsel. There's no shortage of things for us to talk about for the next 15 minutes, but I want to summarize the state's argument into two primary prongs. First, this court is unable to review the vast majority of Mr. Graham's arguments due to a lack of jurisdiction, a failure to preserve error, and a lack of a sufficient record to address the arguments presented. Second, even if the court were to reach the merits of whether Iowa Code Section 903B's special sentence or Iowa Code Section 692A's sex offender registry requirements are cruel and unusual punishment, I think we can all agree that the claims fail because they're legally unsupported by Iowa's existing precedent. I'm going to begin with Iowa Code Section 903B's special sentence. First, the court is without jurisdiction to hear the argument. Mr. Graham has the ability to petition the Board of Parole to change the terms of his special term of parole. That's found in Iowa Regulation 201-45-2, which sets a standard term of parole, but also allows for additions and deletions for each individual defendant.
If it's a categorical challenge, can't they raise that now?
I believe the proper procedure would, again, even if you're bringing a categorical challenge, you would still need to demonstrate that even applied to you, this punishment is cruel and unusual, and I think that would require an exhaustion of his administrative remedies that are available. Even so, we simply don't know the terms of Mr. Graham's special term of parole. It's not in our record. We don't know what additions or deletions may exist or what...
Well, that was true in the Kansas case too, I guess, and what the Kansas court did, as you know, is just cite the ordinary parole conditions. And we see them all the time. I mean, we know what the parole conditions are. I mean, it's 1 to 48 or whatever, you know, and there's usually some potential for variation. But is it really fair to say that we're going blind and that the parole conditions is going to be we don't really know? I mean, to be blunt with you, I think I know what the probation terms are going to be with 97% certainty. Push back.
Certainly, Justice Apple. I think our doctrine of constitutional avoidance would caution us against overthrowing an entire statutory framework that otherwise might be constitutional as applied or categorically applied to juvenile offenders. I don't think that flying blind, as you've characterized it, is appropriate in this instance, even if you were sufficiently confident what the terms might be. Turning to the categorical challenge itself, as the Kansas Supreme Court opinion indicated, there's no national consensus for or against special sentences like 903B.
Yeah, the Kansas Supreme Court cited Lyle at great length. I've never seen a quote longer than that, a block quote of almost a page, suggesting that national consensus wasn't required. And indeed, the Kansas Supreme Court used their independent judgment after determining that there wasn't.
And you've turned to the exact next issue, which would be independent judgment. And I think even using this court's independent judgment, none of our prior cases, including Lyle, support an expansion of it beyond its terms to this type of special sentence, where an individual is free to live in the community, complying with the terms of their special sentence, but otherwise demonstrating that they are rehabilitating.
Can we switch to the registration
Certainly.
issue? And I want to start by focusing on what I call a 2,000-foot rule. We all call it the 2,000-foot rule. We've got some case law on it. We've got Searing. We've got Fomero. We've got a number of cases, actually. And we seem to have said that it wasn't punitive.
That's correct.
It certainly said that in Searing. Seemed to be based on the assumption, though, that among other things, that this recidivism rate was high for these offenders. And the empirical evidence has been developed, and it's not just one study. I mean, there's 91, I think, total, suggesting that recidivism rates of sexual offenders is really quite low, and particularly juvenile offenders. First, does that change? Does that provide a basis for changing the analysis in Searing? Or you can challenge me on the empirical assumptions that I'm making.
I appreciate the invitation. I think you're right to question the empirical validity. The numerous studies that have been cited in journal articles date from even up to 20 years ago. Further, we don't have consistent methodologies. We don't have consistent terms. I think it's commonly accepted by practitioners in the field at this point that the actual reporting, arrest, and conviction rates for sex offenders are substantially below the actual number of sex offenses that are occurring. So I don't think that us quibbling about whether or not the empirical evidence supports it is appropriate in this case. Additionally,
but I don't think it's a quibble. I mean, I agree with some of what you're saying, and that is that these studies have all kinds of different architecture, and you can't compare study A to study B necessarily. But it seems to me that there's actually a consensus among clinicians, at least, that the notion of high recidivism with respect to youthful sex offenders just ain't so. And then secondly, there seems to be a consensus among clinicians that to the extent there is recidivism, it's usually within the household or with people which the offender is familiar. And if both those assumptions are true, this 2,000-foot rule looks pretty odd.
if I may, Your Honor, I'd respectfully push back against that for a couple of reasons. One, legislative determinations are based on more than just sheer numerics. The Iowa Code, the Sex Offender Registry was also based upon a concern about the devastating effects of sex offenses on their victims. That happens even if the recidivism rate was less than 1%.
I'm really directing my fire right now at the 2,000-foot rule. I mean,
the 2,000-foot rule exists because of this concern. I understand your position that it might be perhaps.
It doesn't say 2,000 feet from the victim. I mean, one could well understand some kind of regulation that says that that a youthful offender's got to stay away from the prior victim. I mean, that makes full sense. But the problem that I'm just exploring a little bit is that there seems to be a lack of nexus between the purported purposes of this 2,000-foot rule and its effect on, I mean, it seems disproportionate. I mean, my heavens. If you can't reside within 2,000 feet of all the, daycare centers, schools, libraries, a long laundry list, the burdens are very substantial, and the gains are ephemeral, if the science is right.
Well, respectfully, your question also presumes two things. One, that all sex offenders are only perpetrating against individuals inside their own home, and it also presumes that the sex offense registry is punitive. Again, neither of those things have been previously held by this court, and again, I would caution this court against lumping all sex offenses into one particular offender.
In Formaro, which was 2009, we upheld the 2,000-foot rule. Has there been some dramatic change in the science since 2009?
Not that I'm aware of.
And let me ask you another question about the registry requirements. In order to accept Ms. Wilson's argument, then we would have to find that those requirements are punishment, which would then mean that they would be subject to the ex post facto rule. Is that correct?
That's correct, Your Honor.
And then that would have a lot of collateral effects, not just on juvenile sex offenders, but all sex offenders. Now we would have different regimes. The regime that would apply to each sex offender would have to be the regime that was in effect at the time they committed the sex offense, not the present regime. Isn't that right?
I would agree. I would also note that the current formulation of our sex offense registry is in fact relatively kind to juvenile offenders who are released back into the public before they're age 18. As a minor, you're not subject to the 2,000-foot restriction on residence. So I would again argue that the sex offense registry is not sufficiently punitive in effect to constitute punishment. On briefly the due process arguments that Mr. Graham presents in this case. I would note that none of these due process arguments were presented to the district court below. They were raised for the first time on appeal. And I believe the Court of Appeals correctly characterized them in challenging the manner in which Mr. Graham's 903B special sentence was imposed, as well as, if this court were to consider 692A as punishment, the manner in which that was imposed. Again, these are arguments that must be presented in a district court, have a record built, and obtain a ruling, and presented up on appeal as required by Tyndall.
Well, Kansas considered that issue too, and as you know, came out differently. If I can characterize the Kansas Supreme Court, they basically said, well, if it's a straight up question of law, a claim involving cruel and unusual punishment does not need to be presented to the district court. And clearly, clearly, if there were factual issues, it would be almost incomprehensible not to have it before the district court. But to the extent the due process claim involves a straight-up legal question, it seems to me the downside of not requiring a district court ruling may not be all that high. Why don't you respond?
Certainly. I'd respond in two respects. One, specifically, the Nebraska statute is significantly different than Iowa's. While that may not resolve Kansas, thank you.
But you're right.
And the second point would be that, again, I understand the argument that a court would be without legal authority to impose this sort of sentence on a constitutional argument, that can be raised for the first time in appeal. But I don't think when we're talking about whether or not it was, whether the manner in which it was imposed procedurally is correct.
What they're saying, I think the argument is, and I may miss it, but I mean, it's an irrebuttable presumption they claim. And they also claim that that's a straight legal argument. It may not be. I mean, to the extent it requires factual development, the argument is awfully strong that you got to file in the district court first. But if it's a straight up question of law, once again, I'm not so sure that the rationale for exhaustion is quite as strong.
Well, if we could talk real briefly about the irrebuttable presumption doctrine, it's not employed in this state, and frankly, I don't believe, other than in Ray J.B., the Pennsylvania case, that an irrebuttable presumption doctrine is built into their state constitutional law. It's not applicable in Iowa. Really, what would need to occur is a substantive due process argument, which has not occurred in the briefing at this point. If there are no further questions, I would like to point out that the way in which this statute, both 903B and 692A, are constructed is that essentially after a term of years where an individual has demonstrated rehabilitation, they're able to petition the Department of Corrections and the Department of Public Safety, present a record that they have in fact rehabilitated and have become successful members of our society, and discharge these sentences.
There's nothing in the record, I take it, to show whether sexual offenders are relieved of their special sentences?
There's nothing in our present record. I know the number of individuals that have been released, but that's not in our record.
And do you agree with Ms. Wilson's reading of 906-15 that that what that last sentence does is it says you can be released from the special lifetime sentence, but not until you've served what would have been the period of the full term of confinement? If it's an indeterminate sentence of 10 years, you can't be released for 10 years. Is that the way you read it?
That is my reading of it, Justice. I believe that the legislature was sufficiently concerned with individuals perhaps being released from the registry too soon, but it still left remedies available for them to demonstrate rehabilitation and be removed. It's simply Mr. Graham cannot be relieved of his obligations under 903B or 692A until 2020. But at that time, he will hopefully have successfully rehabilitated, integrated into Iowa's communities, and been able to...
I appreciate that, but why don't you respond then to Ms. Wilson's argument? I mean, she kind of closed before she sat down with a person committing suicide walking out in traffic. But the overarching notion was that these registration requirements involve, putting words in her mouth, I suppose, but involve public shaming, that they impose draconian impacts on children, and that whatever marginal gain you might get from these requirements is far outweighed by the devastating impact on the individuals. You understand the argument?
I certainly understand the argument, and I appreciate the question. I think the answer is multifaceted. One, our sex offender registry statute already builds in significant protections for juveniles. As Ms. Wilson noted, if the individual is under the control of the juvenile court can, upon a showing, waive registration requirements entirely. Juveniles are not required to, are not barred from going to the school where they're a student. They're not barred from being on school grounds where they're a student. They're not subject to the residency restrictions.
But what about persons that have adult convictions in adult court?
Sure, they are. However, the impacts that Ms. Wilson is referring to would be no different than if a high school student who was convicted of this crime and was still in high school and his peer mates found out the fact of conviction, which would be public record. Nothing about 692A's registration changes that analysis. Also, I don't think that the effect of third parties, non-governmental, can affect whether or not a punishment is cruel and unusual. If there are no further questions, I certainly appreciate the court's time. Thank you. We would ask that you affirm the Court of Appeals decision.
Thank you as well, Mr. Howe. Ms. Wilson, rebuttal?
I do have a number of things I want to say, but first I wish to address Justice Mansfield. Just to be clear, my initial impression of 906-15 was that if you were on a special sentence, you had no confinement and therefore you were never eligible for early discharge if your conviction was under 7093, 7094. The Court of Appeals interpreted it differently based on referring back to the underlying criminal conviction, and that certainly alleviates some of my initial concerns, but I don't think it alleviates all of them. I want to go to the issue we talked about, the fact of conviction being public. Absolutely correct. Anybody can go into ISIS with a name and a date of birth and find out if somebody has been convicted of a public offense or a sex offense. The problem with that is that's a relatively simplistic way to look at it because you need a name. You need a date of birth, ideally. I can go onto the sex offender registry and put in my home address and find every registered sex offender in a geographic location.
In fact, my kids showed me how to, on our iPhone, we bring up a map of our neighborhood and it has little pins where registered sex offenders live, not immediately nearby, but you can see that, and then you click on that and opens it up, and it brings up their name and mugshot and information on them. So I understand that the registration is an extra step towards notoriety compared to just the fact of conviction, right?
Absolutely, and it can be particularly damaging to juveniles, because then you can look up that they're a Tier 3 offender. That doesn't tell you anything about their actual risk to anyone, but lay people are going to make assumptions based on that. There was a lot of discussion of the 2,000-foot rule. I want to just elaborate on what has changed since 2003, which I think is the statute that searing was based on. Under 2003, there were no exclusion or loitering zones. There was no special sentence in effect at the time. So my client, who is now a Tier 3 offender and has a lifetime special sentence based on his particular offense, would have been subjected to the default 10-year registration requirement under the old code. The violation was an aggravated misdemeanor or Class D felony. As an aggravated offense against a minor, my client is subject to a Class C felony. The tiers now allow for more than just annual verification of relevant information by mail. As a Tier 3 offender, my client has to go in every 3 months and personally verify his information. The registry information dispersed was also different. It was considered confidential except on a request, where the person requesting the information had to provide specifics. Then the person requesting information could also get information about anybody who was at risk in the county. The only information that was provided electronically were for moderate and high risk offenders, not low risk offenders. So the information dispensed back then was a lot different than what's dispensed now. And currently our system, our registry system, isn't based on any individualized specific risk assessment. It is based on simply the fact of conviction for a particular offense. And as indicated in the Sex Offender Research Council report, that classification simply doesn't work for juveniles. I also want to point out one unique feature of juvenile offenders when it comes to, I suppose, both the special sentence and the sex offender registry. Juveniles, based simply on their age and their peer group, are much more likely to have a sexual offense against somebody younger. It's one thing when we're talking about a 60-year-old man who's perpetrating against a 13-year-old. We are talking potentially about 14-year-olds, 15-year-olds, 16 and 17-year-olds perpetrating against a 13-year-old. And they are now put in my client's position where he is now convicted of an aggravated offense against a minor. So we are putting these juvenile offenders in a category that would mark them as perhaps the most highly at-risk offenders. We're certainly treating them that way, but they're not actually, based on the studies, likely to commit sex offenses again as a juvenile. So for these reasons, I would ask that the mandatory nature of the special sentence and the sex offender registry be vacated, that any mandatory waiting period prior to discharge or modification also be vacated. Thank you.
Ms. Wilson, thank you as well. Case of State versus Graham then is now submitted, and we'll next hear the arguments in State versus Harris. And I think the Marshalltown students need to leave, is that right? Okay, well, thank you again for being here this morning, and enjoy the rest of your tour.